Good morning, everybody. We're going to call the meeting to order now. I'm Chair Kathy Lewis, and this is the Board of Appeals meeting set for December 13. It is December 13th, 2024. We're going to be holding this meeting both in person here at the Kona Council Chambers, as well as virtually by the Zoom platform. And I'd just like to go through very quickly the protocol for Zoom. We have quite a few people on Zoom today. So hopefully everybody on Zoom knows how to mute and do all those things. First of all the cameras must be turned on at all times during the hearing. One person speaks at a time and no side conversation, please. We want to try to keep the record nice and clean and easy for people to transcribe if they need to. Please mute your device when you're not speaking. That will improve the audio quality for all so it doesn't pick up background noises. Please raise your hand, wait for recognition by me before speaking, just to ensure that we do have a clean and clear record. And then prior to speaking, please state your name so that all parties know who is speaking. And if it's not obvious, you can state your position in terms of the matter at hand. Please speak slowly, clearly, and close to your microphone. And try to limit distractions by turning off other devices and mobile phones. Zoomers, and as a general reminder for all Board of Appeal members, please state your name before speaking throughout our hearing today, those of you on Zoom. So now I'd like to have the Board of Appeal members and the staff please introduce themselves. I'll start first. I'm Chair. My name is Kathy Lewis. And
Lisa McNamara.
Scott Martin. Scott Martin.
Good morning. I'm Noy Psyche, Vice Chair.
very good. And yeah.
So Chair, I'll just note we do have quorum with 4 members present today. Note that that is the number for quorum. So in order for all motions to pass, all 4 need to be voting in approval of that motion. And that's according to the Hawaii County Charter, section 13-4G. Thank you.
So if somebody doesn't vote, then do we continue the matter?
Then the motion would fail for today, and we can talk about those considerations later. So that comes up.
And did you introduce yourself, Ms. Wan?
Sorry, Deputy Corporation Counsel Sylvia Wan. I am counsel for the Board of Appeals. We also have staff members, April Supernaut and Ashley DeVera, who are Board of Staff members.
Excellent. Did you? Okay. All right. At this point, this is the time when we take statements from the public. My understanding is that there is nobody from the public that is here or on Zoom to speak. Is that correct? Now, that doesn't mean you're not here to do other things, but just to make public statements.
Just a moment, Chair. I believe we just got a late submittal, and April is going to confirm what matter he would like to testify on and when.
Okay. So far, so good here.
Aloha, Chair. We have one in-person testifier, David Fisher.
Okay, excellent. Mr. Fisher, if you'll come to the table over there, take the microphone, make sure it's working, and you can make your statement. You get 3 minutes.
And if you could, once you get your mic situated,
Yeah. The acoustics in here are very bad. I can't even hear what you guys are saying. I'm not sure if I'm in order here or not, because I'm here in reference to, I guess it's one of your new item, or your new business items. Title number 5 under new business. Beverly Maragos, I believe is one of my neighbors. And this has to do with a project that was started about a month and a half ago. And we in the neighborhood knew nothing about it until the construction equipment showed up. And I find it a little bit disconcerting because when projects start that are funded by the county or the county has anything to do with, you would think they would notify the residents in the area that something's going to happen. And we didn't have a clue. Anybody in the neighborhood did not have a clue. And so that's the first thing. There's a bunch of other things that we could talk about, but basically the fact that we were disrespected by the county really bothers me, because this is supposed to be government of the people. You know, we're talking public servants here that are our representatives who wouldn't even bother to respond, basically, to the situation. And I think, you know, we could go on about this, but the project itself, I think, is flawed from a safety standpoint. I don't mind the sidewalk that's being installed, but the idea that we're going to remove a barrier and allow through traffic in this area really concerns me, because suddenly we're going to turn from a neighborhood into a thoroughfare. And there's a lot of negatives on that. You know, we could talk about valuations of property, that kind of stuff, i.e. that means less revenue for the county as well. But also from a safety standpoint, because the slopes leading into that area are probably would not be allowed now. They're very steep. Even though it's a paved road, we're talking, according to the signs, 18% slope. And on wet pavement, it's pretty hard to slow down. And we're going to have a lot of people come through there that aren't familiar with the area. And they're going to try to make a curve coming off an 18% slope. And they could very easily slide into my neighbor's house or my house, trying to make that corner. And then you go on further down this road, and you start going down Akaala Street. It's
15
even steeper.
15 seconds remaining.
I'm sorry, I cannot hear you.
15 seconds remaining. Actually, it's far less now. Can you please
I can't
conclude?
hear what you're saying.
These are limited to 3-minute statements, so you have 15 seconds remaining.
Oh, I didn't know what the deal was in this. Okay, bottom line is the Akaala Street is even steeper and more dangerous, and people have slid off of Akaala into Napo'opo'o Street, and that's a pretty busy road. And so with that said, I'll sit back down. Thank you.
Thank you so much for your testimonies. Okay, then that concludes public testimony. I would like to announce right now, just as a transition point, that I am going to switch the order of the published agenda. We're going to be taking Maragos after Oceanside before Belisario, so that fewer people have to sit around and wait for the longer item. All right, we're now moving on then to old business. And the first case is 1250 Oceanside LLC. That's PL-BOA-2024-000104. And we are taking up the written proposed findings of fact, conclusions of law, and decision and order to to affirm the planning director's declaratory ruling on docket number 24-001. dated April 29th, 2024. This was in response to C&J Coupe Family LP petition for declaratory ruling dated February 7th, 2024, and supplement to the petition for declaratory ruling dated March 27th, 2024. This is regarding dedication of Mauka Halaki'i Extension, Makai Halaki'i Extension, and Connector Road to the county, and a request of public hearing. Are there any public testifiers on this agenda? Public testifiers.
There are no public testifiers, Chair.
All right. Will the names and appearances of the parties please introduce themselves? We'll start with the appellant.
Good morning, Chair Derek Simon, and with me is Patrick Wong there in person, appearing on behalf of Appellant 1250 Oceanside LLC. Thank you all very much.
Thank you. And the intervener? Do we have someone representing the intervener here?
Good morning, Chair. Kenneth Kupchak, Mark Murakami, and Torin Yamamoto on behalf of the Coupe family, who I understand are present live as well.
Very good. And finally, department.
Good morning, Deputy Corporation Counsel Jean Campbell on behalf of the department.
Okay, very good. So we are to consider the adoption of the, as I mentioned, proposed findings of fact, conclusions of law, decision, and order. And to the board members, has everyone had a chance to read the proposed findings? Okay, is that a yes from Scott as well? Yeah. Okay, all right, very good. All right, and the order submitted by the department. Everybody had a chance to review that? All right. So I would.
Also the objections.
Oh, and has everybody familiarized themselves with the objections filed? Okay. All right, now I would entertain a motion for regarding the proposed findings of fact. Will anybody make a motion? I don't like to have to make the motions. Okay, I'm going to make a motion that we approve the proposed findings of fact, conclusions of law, and decision and order.
Do you want any amendments to that?
Well, I thought perhaps we would get my my motion underway and then have a discussion.
Deputy Corporation Counsel Sylvia Wan. So you can do a motion to approve. If you are going to consider amendments to the form of the order that's been presented, just know that you're going to have subsequent motions to amend
Right.
your original motion.
So it would be simpler, since nobody else is speaking, that I should just go ahead and do it with amendments, or is somebody going to be speaking on any amendments within here?
I think that's up to you. If you already have in mind particular
don't
amendments,
really-
you can start, or I'm just giving you options here.
Yeah,
Why don't you go ahead and go through your amendments?
all right. All right, I'm going to,
If you,
since nobody seconded my motion, I'll start over, I guess.
so,
Robert's rules are. a little-
do you have an idea of about how many amendments you do want to propose? Because if there's more than one, then maybe you should do it singularly, approve, and then amend, and then amend, and then
I
amend.
wish I wasn't the one that had to do this, but. All right, well, hang on a minute. Let me find the amendments that I would like to see. All right.
Okay, Chair, just based off of how this is going at the present time, Why don't you start with the simple motion, which is to approve the proposed findings of fact, conclusion of law. Get a second, we'll open it for discussion.
Okay,
Based on discussion, then you could decide to amend it
okay,
as we go along. That's probably the easiest way to go forward.
all right. Mostly it was taking a minute because I wasn't ready to be the one to do.
I'll second your original motion.
Okay, thank you. Any discussion? Okay. All right. I'm going to find that there are some gaps in this. Not necessarily in terms of the conclusion, but just to get to the conclusion. So on item number 9 in the proposed findings, hang on a minute. Hang on just a minute. I'm not fine. Hang on a minute. I'm sorry. I do apologize. So I said I didn't think I would be. Okay. Yeah, okay. So the findings of fact. Yeah, okay. So on number 9, which states on October 11th, 2024, the board heard oral arguments, presentation of evidence. I would propose including the following language, comma, including exhibits, comma. It's implied, but I think it's good to state it and note for the record that we have exhibits. And I'll go ahead and add the next one, and then maybe we can vote on that,
On those two.
on 2 of them. Because that one's fairly unobjectionable, I would think. All right. So I would like to insert a finding of fact to this finding I feel reflects the board's discussion and reasoning. And hang on a minute. I'm not finding it. Oh, right. All right, here's the language. It would be the very first finding of fact then. So actually, I'm going backwards again here in terms of the number. All right. So Jean Campbell, although present at the hearing, no, that's not it. I'm sorry.
Chair, do you want to just have the members, are you proposing an amendment to paragraph 9 of findings of fact, just to include exhibits? Would you like the members to at least vote on that first? So you have a moment to collect yourself for your next
Okay.
point?
All right. So with just that one,
There would need to be a second to that amendment.
okay.
Oh,
So,
second that.
thank you. All in favor?
Well, I guess there would need to be a discussion. Is there any
Oh,
discussion on that
discussion,
amendment?
I'm sorry. Discussion?
No.
All right. All in favor? Anyone opposed? Okay, that carries.
So I'm just going to note that Noy, Lisa, and Scott all voted in the affirmative, although the mics didn't all catch it.
I'm not fine. Hang on a minute, please.
This is the one.
Why can't I see it? Here it is. It's there. Okay, right.
Inserting it as a number 10.
Oh, okay. Yeah. Okay, I'll make a motion to amend the, excuse me, the findings of fact to add number 10. And The proposed language is as follows. The board found that the order addressed the questions raised by the appellant in its appeal, even if the director did not provide the level of clarity or specifics desired by the appellant. So I would entertain a second to that.
Second.
All right, a discussion? Damn. Any discussion? Okay, then we'll vote on that. All in favor to that?
Aye.
Aye.
No, She said
Aye.
aye. Okay, and I said aye.
Are there any nays?
Any nays? Thank you.
Hearing and seeing none,
Yeah,
that motion passes.
that motion passes. All right.
So the motion has been amended now twice.
Right. Don't have the one with the. I have too many things here. Here it is. Oh, this is 5 of them or 4.
So Chair, let's take them each in turn if you have 5 different items.
It's easier. Yep. Okay, now, I'll make a motion to amend the findings of fact to and conclusions of law. I'm calling, just for shorthand, I'm calling this document findings of fact. But I want to amend the conclusions of law. We'll start with one of them, okay? The first would be number 2. I'm looking, hang on a minute, let me get to the regular one. Proposed. Where are the- Oh, there, okay. So this is going to be a new number 2.
No.
No,
These suggestions are just.
I see.
What I'm suggesting is that it's false.
Uh-huh. So it's gonna be 5.
So that would be.
Yeah.
Okay.
Thank you. That's kind of sad. All right, the first one I'll do them one at a time, just for clarity. So the first one would be numbered 5. It would be a different number 5. And it would state the following: the director acted within his jurisdiction when the director addressed the posed questions in his order. That is the first proposal.
So just for clarity's sake, Chair, what you're proposing is that under the conclusions of law section,
Which is page 3, yeah.
to appear after paragraph 4, which would be a new paragraph 5, would be the language that you stated. The director acted within his jurisdiction when the director addressed the posed questions in the order. Is that correct?
Correct.
Okay. So that's a motion to amend.
It is a motion to amend. Is there
I
anybody
second the motion.
Second.
Okay,
I'm not sure who was first, but I heard Scott first. So I'm going to have Scott as the second.
everybody wants to second, but that's all right. Any discussion on that? All right, we'll take a vote. All in favor, say aye.
Aye.
Yes.
Sorry, can the members do that one more time with your mics on?
All in
Yes.
favor, please say aye.
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 All opposed? Okay, that passes. All right. My second amendment, proposed amendment is going to follow next. So this will be a new paragraph 6. And it will state the order correctly identified issues outside of the director's jurisdiction and discretion. Everybody?
Point of clarification, Chair, a new 6, so you have a new 5, which means the existing 5 will be 6.
Just
So
keeps
is
bumping
this
down.
This is a new 6 under the new 5.
No.
Correct. She's right.
And therefore, the existing 5 will become 7?
Right, that's what, so it just bumps the last one down.
Okay, I just want to be clear so we know. Thank you.
Absolutely. Yeah. All right, now, right, I need a second.
I'll second it.
Thank you. Discussion, please. Any discussion? All right, then all in favor, please indicate with aye.
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 Any opposed? Okay,
So
hearing
and
none,
seeing no.
that motion passes. That amendment. Okay, I've got 2 more, so then the next one will be a new paragraph 7, a move to amend the order to add a new paragraph 7 under the conclusions of law. This would be the order sufficiently addressed the questions raised by the appellant, even the order did not reflect the specifics desired by the appellant. And that's it. Would you like me to repeat that?
Yes.
The order sufficiently addressed the questions raised by the appellant, even though the order did not reflect the specifics desired by the appellant.
Second.
Okay, we got a second. Any discussion? All right, all in favor of this, say aye.
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 All
Aye.
opposed? I'm sorry. All opposed? Hearing none, that amendment passes. That motion for an amendment passes. And I have one more proposed amendment, and that's going to be a new number 8 in the conclusions of law. And it would state appellants argued a lack of clarity and or specifics in the director's responses, but that did not meet the burden required for modifying or remanding the planning director's decision. I'm going to repeat that since that's a little dense there. All right. Appellants argued lack of clarity and or specifics in the director's responses, but that did not meet the burden required for modifying or remanding the planning director's decisions.
I second that amendment.
Okay, any discussion? All right, all in favor, please say aye.
Aye.
Any opposed? All right, that, hearing none, that motion and amendment passes. And April, just for clarity, then that leaves that one last original. All right.
So for clarity, the original paragraph 5 as proposed would become paragraph 9 under conclusions of law.
And I have one final sort of rewording I'd like to propose in the decision and order itself, which is and actually the very last paragraph of this document. If you all want to turn to that, where it says appellant's appeal of, I'd like to cross out that language and begin with the planning directors, and then continue all the way as written until it says is denied, and cross out denied and say affirmed. So now it's going to read, if the motion passes, it will read the planning directors, April 29th, 2024. Zendo Kern, Planning Director, County of Hawaiʻi's declaratory order in the matter of C&J Coupe Family Limited Partnership. Petitioner docket number 24-001 is affirmed. And then the last sentence remains unchanged. Basically, oh, go ahead.
I'll second that.
Thank you. Any discussion? We're just basically turning a negative into a positive kind of.
Okay, and just for record of clarity's sake, that is the last paragraph on the decision and order. First sentence is being amended in that fashion.
Correct, correct. Okay, any other discussion? All right, then I'll take a vote. Any, all,
I'm sorry, did we have a second? Oh, Lisa seconded.
yeah.
Okay, sorry. Go
as
ahead.
I discussed.
Yes.
All right, any, all right, so all in favor, please say aye.
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 Any opposed? All right, so hearing no opposition, that amendment, that final amendment passes. Oh. Yeah, I guess so. All right, I missed one where it's basically, again, a rewording to make it more of a active versus passive language. So this is now going to be that, so I'm going to move that the conclusions of law be amended, the old number 5, which is now number 5, 9. Okay, hang on a minute. Okay. All right. So I'm going to, if you can follow along, board members follow along, and I will indicate where the changes will be. Having considered the testimony and evidence provided, the board unanimously concluded rather than ruled. So that's the first change. That in issuing his order, the planning director, Zendo Kern, did not clearly err, was not arbitrary or capricious, nor did he abuse his discretion. That's unchanged. Therefore, the board affirmed Zendo Kern, and the rest is unchanged. So we're crossing out denied appellant's appeal of and turning it into the active voice of therefore the board affirmed Zendo Kern, and the rest remains unchanged. That's it from me.
I'll second that.
Okay, any discussion? All right. All in favor of this amendment, please say aye.
Aye.
Any opposed? Thank you, Noe. Any opposed? All right, hearing no opposition, then that final amendment passes. Thank you for keeping me on task. That was a little.
Okay, so if the chair is done suggesting amendments, then what is left on the floor is the original motion to approve the proposing findings of facts, conclusions of law as amended. So that would be on the floor for discussion
Okay.
presently.
It's been seconded. It's all
You've already
seconded, so-
been seconded.
So the discussion now is to really the merits of whether we're going to adopt this findings of fact and order in its entirety as amended. Any discussion on that? Okay. Okay.
So, Chair, can you just call the question just so that everybody's clear?
Okay. How do I call the question?
So it would be restating the motion. So your motion is to, okay, I guess I'll just call the question for you then.
Please.
The chair's motion is to approve the proposed findings of fact, conclusions of law as amended by the subsequent amendment motions, rather than having to state it all into the record once more, since the board has voted on each and every single one of the amendments. So that's the call of the question. And since this is approving the final form of the order, I would ask, if you're going to ask for the vote, that it be roll call.
Okay. So is there any discussion?
Well, that's the call to question. So now it's voting.
Oh,
Because they said no.
there was no discussion. All right. So we'll have a roll call vote. And please state your vote when your name is called.
Board Member Martin,
Aye.
Board Member Psyche,
Yes.
Board Member McNamara,
Aye.
and Chair Lewis.
Aye.
You have 4 ayes, motion passes.
And that's it. All right, thank you for bearing with me. That was a little bit painful. All right, so get back to this. Now, we are going to do it all over again for the second Oceanside case. Now, the conclusions of law, the findings of fact, conclusions of law, decision and order are virtually identical. Is there any way we can somehow shorthand this process a little, where we adopt en masse all the same amendments?
Miss Campbell, I understand that you were the drafter of the original proposed findings of fact, conclusion of law. Can you attest that they are identical outside of the changes relative to the respective declaratory orders?
To my recollection, that's correct.
Obviously, case numbers and things are different.
Yeah, and would 1250 assent to that? 1250 Oceanside?
Yeah, hi, Ms. Swan, Derek Simon, on behalf of 1250. I don't think there's a problem with that, although I think the numbering is off, as far as referencing. I can double check here, but I think there's maybe one more or two more factual findings in the proposed order. I could be wrong on that.
Oh, okay. I don't even know which is which.
Chair, do you want to do a short
actually,
recess, please, just so we can pull up those orders?
Okay, well, let him finish. Maybe he can.
Yeah, actually, maybe not. Maybe I misspoke there. I apologize. The numbering's the same. I apologize.
So it
Okay,
appears that the parties are both affirming that the second order for case number 105 is the same. So if you want to adopt the same changes as in the findings of fact, conclusion of law adopted by the board for case number 104, you can do that type of motion.
okay. Does anybody else?
Oh, I'm sorry, before we go forth, does the intervener have any objections to proceeding in this manner? Do you have any objections? Do you agree that the order is the same?
We have no objection to your proceeding that way. Thank you.
Thank you.
Okay. All right, then I will make a motion to adopt the proposed findings of fact, conclusions of law, decision and order with the amendments that we just passed for the related case. Without restating them, that is my motion.
I'll second that.
Any discussion? Okay, we'll do a roll call order, or hearing no hearing no discussion, let's have a vote on that, and we'll do the roll call order again, just to be clear.
Thank you, Chair. Member
you.
McNamara,
Aye.
Member Psyche,
Aye.
Member Martin,
Yes.
and Chair Lewis.
Aye,
You have 4 ayes, motion passes.
thank you. Thank you very much. Is there any clerical kind of thing that I need to tell them about?
Uh,
Oceanside.
No, but the staff will follow up to make those changes as approved by the board. And we'll submit them to the chair for signature once those changes have been added to the new form of the order. Thank you.
Okay, just an announcement, a new business, on our original agenda, we had EO processing, or is it IO? It's IO, isn't it? It's EO. See, now you got me. EO Processing Company, doing business as EO Processing Company. And that was PL-BOA-2023-000065. That item has been continued to the February 14th meeting at the request of the parties. All right. So that means now, as I mentioned, we're going to take the Maragos matter up because that way those people will not have to sit through a contested case hearing. This matter, Maragos, hang on a minute, please. This matter is being taken up on the motion by Beverly Maragos, who filed the complaint here. It's PL-BOA-2024-000112. The Director of Public Works has filed a motion to dismiss based on a lack of timely complaint or petition. And this is regarding the Director of Public Works, June 20th, 2024, issuance of permit number 25910 to work within the county right-of-way. If you would please let me know your name and the manner, the person you're appearing for, the parties in this matter, starting with the appellant, please.
My name is Randall Yamabe. I'm here representing Beverly Maragos. And I'd like to acknowledge Beverly for the work that she's done to let us be able to partake in this process.
Right. And we appreciate your asking about that ahead of time. Next.
Good morning, Chair, fellow Board of Appeals Commission members, Deputy Corporation Counsel Sinclair Solis Ferguson on behalf of the Department of Public Works.
Okay, I do want to mention that this is a motion and we're not taking, testimony, or this is just an argument over the motion. I give each side about 5 minutes and then we'll take up the matter on the motion. So, what's his name? Okay. Hang on, just trying to find his name. Oh, here it is. Okay. So the issue here is, well, first of all, I'd like the sides to know that we have read the motion and the response. And we'll ask you not to repeat what you've already provided us. There is one legal issue before the board, and that is whether the petition was timely filed under the rules that apply with to this. And let's begin that. We'll start with the movement. That would be you, Mr. Yamake, or Yamabe?
No.
Oh, no, I'm sorry. I'm sorry. Yes, of course. It's department. So start with you.
Thank you, Chair. And I just want to begin by addressing some of the comments from the gentleman earlier. So, and by talking a little bit about the process. So when a subdivider develops a piece of property, they have an option of keeping some of the streets private, or they can build them to dedicable standards to be dedicated to the county in the future. So there was a private property landowner that subdivided property and anticipated that they would dedicate some streets to the county. Two portions of the street at issue were dedicated, and there's a third portion, lot 2, wasn't dedicated. So the landowner approached Public Works, basically with the intent, the conversation of like, hey, what do I got to do to dedicate this? So Public Works spoke with them and said, you got to, do this, this, and that, and we'll issue this permit to monitor your progress, to come out and inspect, like, whether the curbs installed properly and up to the specifications that Public Works requires. So the process for that is that once they're done with their road, they submit it to Public Works. Public Works goes out and inspects it and makes sure, okay, this is built to dedicable standards. And then it'll be put before County Council, the Hawaii County Council, for dedication, for the county to take it over and take over ownership and maintenance of that. And the authority for the county to take over that road rests with County Council. So that's the process for this street to be given to the county. The gentleman earlier, I just want to correct something that was said, just so everyone's on the same page, is that this isn't a county project. This is a private landowner doing work on his private property. And it's going to be up to the County Council to accept it or not. For the motion, it's very clear. There's a deadline, and I'm not addressing. So before an appellant can even get in the door, per se, to argue in front of this board, they have to file the appeal within 30 days. They also have to have standing. So I'm not addressing that. I'm just addressing today the limited question of whether or not this board has jurisdiction, whether the appellant timely filed the appeal. And in this matter, it's very clear that you're required to file the appeal within 30 days of the decision. The appeal was filed 131 days later. Therefore, the department asked that this appeal be dismissed as an untimely filing, and that the Board of Appeals doesn't have jurisdiction to hear the matter. Thank you.
Does anybody have any questions of Mr. Silas Ferguson at this? Okay, Mr. Yamabe.
Okay, I'm gonna read so I don't get off track here.
No problem.
Yeah, thank you for allowing me to give my testimony today. My testimony is for the purpose of encouraging the board to disqualify and/or dismiss DPW's motion to dismiss. These are the reasons for disqualification based on BOA Rule 8-3C. Rule 8-3C states in part, the director may file an appropriate motion with the board within 10 days from the date of the petition filing. In the board's plan number PL-BOA-2024-000112, the applied date of the appeal is listed as 10/29/2024. In the introduction of the DPW's motion to dismiss for lack of jurisdiction, it is stated in part that the appellant filed her general petition of appeal on October 29, 2024. On page 3 of the motion, it is stated in part that the appellant filed her appeal on October 29, 2024. In the declaration of Steve Paz in number 6, it is again stated that the appellant filed an appeal on October 29, 2024. It is established in the BOA's case number, the motion to dismiss, and the declaration of Stephen A. Paz that October 29, 2024 is the filing date of the appeal, which is the filing date from which the director has 10 days to file an appropriate motion according to the rule. The declaration of Steve A. Paz is dated November 12, 2024. That is 14 days past the filing date of October 29, 2024. The motion to dismiss is dated November 14, 2024. That is 16 days past the filing date. Based on these facts alone, the motion to dismiss should be disqualified and/or dismissed for not being filed within the 10 days of the petition filing as is required by the rule. In the email from Sinclair Salas Ferguson to the Planning Board of Appeals dated November 14, 2024, it is stated quote, "This motion is filed within 10 days of DPW receiving notice of the appeal." And in parentheses, it says DPW received the appeal on November 4, 2024, unquote. The date of receipt of the notice by the DPW does not change nor nullify the filing date, which is the date from which DPW has 10 days to respond. If they received it on November 4, then they would have had 4 days left to file. They did not file within the 4 days. If the board allows DPW's motion to dismiss as being filed within 10 days of DPW receiving notice of the appeal, then it should also allow the appellant a 30-day time frame to file an appeal from the date which she received notice of the permit to work within a county right-of-way. After a request for a government record to the DPW, the permit was received by the appellant on October 22nd, 2024. The filing of the appeal was on October 29, 2024. This would be well within the 30-day limit to file based on receipt. There is no evidence that any other form of notification of this permit to the affected parties or to the public in general was ever carried out. Per the DPW, no notification is required for this kind of permit. This begs the question, how would one even know of the permit or the date of issue that would determine when the 30-day period would even start with no public notification or notification to the affected parties at least? The concerned residents being affected by the permit were not given the same luxury of notification that the DPW had. Modifying the rule to allow for the time limits to begin upon receipt of filings rather than the actual filing date, and considering that appellant's filing would meet that filing requirement of a 30-day limit based on this modification, then the DPW's motion to dismiss would have no standing. The DPW being an affected party pertaining to the appeal, at least they were considerably notified of the appeal with time to spare to file a motion. In the case of the affected parties regarding the work involved in the permit, no notification was given to them, and no advance notification of the start of work was given either. The affected parties of the work to be done by this permit were completely ignored in the process, effectively taking away any opportunity of protest or appeal. This is the reason it took the actual start of construction work to begin inquiries and delay in response in the form of an appeal. In summary, if the BOA accepts the Rule 8-3C as written, then the motion will be found to have exceeded the required time limit to file. If the BOA decides to accept the DPW's basis that their 10-day limit started on the day they received the appeal, then in all fairness, the appellant should be granted the same concession of their time limit starting from the day of receipt of the permit. The rule is clearly stated and the dates of filing are on record. There is no consideration in the rule for dates of receipt or for any reasons for delay because of a conflicting date of receipt to the actual filing date. Either way, adhering to the filing date or giving an exception to a date of receipt in its place, I am confident that the board will follow the facts and come to the only reasonable conclusion available. Both avenues to a decision lead to the same conclusion, that is, to dismiss the motion to dismiss. Thanks to the board for your consideration of this testimony.
Chair, I used 2 minutes and 48 seconds of my time. Could I use the remainder for rebuttal?
Yes, I was going to ask you if you please.
Thank you.
reply.
So, under Rule 3-12, a motion can be made at any time. There's a little conflict, but I think this rule overrules anything, and that makes sense, right? You don't want to have the board hear a contested case where it doesn't have jurisdiction. In this case, the DPW's position is Rule 3-12 trumps the timing regarding motions, and it can be filed at any time before, during, or even after a hearing. And I just want to point out something for the people here today, supporting the petitioner. The venue for the people concerned about the road to contest it is not here. It's at the county council when it comes before the county council for them to determine whether or not the county is going to take over the road. The county has discretion. It may take over the road only if it's built to certain standards. So that's the time for the gentleman here and the people in the audience to go and air their grievances. Another thing I'd like to address that was brought up is notification. So the Department of Public Works is not required to give people notification when they issue a permit. The only person they're required to give notification is the applicant. For example, if you apply for a building permit, you know, your neighboring homeowners don't get notification that you're getting a building permit. When you apply to do any construction work, there's no requirement that other people get notice. It's the applicant getting that notice. So I just want to be clear on that and nothing further. Thank you.
Any board members have any further questions for either of the parties at this point? Okay. No, okay. Your mic is muted, but that's fine. I could read your lips. Uh-oh, the mic is muted, Noe.
There we go.
There we go.
Yeah, I have no question.
Okay.
It's pretty clear.
I would have then entertain a motion to.
Chair, I'd like to make a motion regarding Beverly Margos PL-BOA-2024-000112. I make a motion that we dismiss for lack of jurisdiction. The board has no jurisdiction in this matter regarding.
Well, we'll discuss that during discussion. Okay. For one
Yeah.
second.
So, just for clarity, I understand you saying dismiss for lack of jurisdiction. Are you then approving or granting the department's motion?
I'm granting the department's motion.
Thank you.
Right.
To
Affirming
dismiss.
it.
The motion is to grant, motion to the department's motion to dismiss.
I'm affirming the department's stance in this matter.
Well, technically, your motion, as I hear it, is to grant the motion to dismiss, which is
Correct.
what we're taking up right now. All right.
Yes.
Thank you. Any second on that?
Second.
All right, discussion, please.
Now, Noe, you can make your comments.
Yes, now.
Okay, so considering the let's see, the Hawaii County Code of, let's see, 2-4, the time and place that that there's more than 30 days that it was filed, according to the testimony by the department's counsel. Yeah.
No,
that's
are you
it.
talking about the board's rule 2-4?
Oh, that's the BOA. Yeah, no. Yeah, that's not us. That's not mine. I'm talking, strike that, please, not the board's rule. Let's see.
Well, no, you originally stated the
That's two
Hawaii
different
County
things.
Code, which I do not think is necessarily applicable, and nobody has filed on that. But
Okay.
I think what you're
Then let's
talking
get rid
about,
of the county code, but use the BOA 2-4 for my reasoning.
okay. So you're citing the Board of Appeals Rule 2-4 entitled Formal Requirements for Filing Documents.
Yeah,
And subsection A is relating to time and place.
subsection A, yes.
Okay, thank you.
Thank you.
I would just like to add to the discussion. I understand the concerns of the public that there should be a time clock running from something of which you may or may not be aware. But you also have to understand that this code is written for a huge number of permits that are issued regularly, and notice for that would be a very high burden for the department to bear. And I'm mindful also of the fact that a dismissal does not totally rob you of your ability to take your concerns and still have them in a substantive way taken up by the county council itself. So those are the two things that influence, my thinking. Anybody else? Okay. Hearing no more discussion, we'll take a roll call vote.
Thank you, Chair. Member Psyche,
You're muted.
you can hold your space bar down.
Still muted.
Unmute.
There you go.
Yes. Hmm.
Member Martin,
Yes.
Member McNamara,
Yes.
and Chair Lewis.
Yes.
You have 4 ayes, motion passes.
I do want to thank the public and people for all your work and coming and. Oh, right. Okay. So, since the vote is to grant your motion, Mr. Silas Ferguson, will you please prepare a form of order which reflects the findings and conclusions of the board?
Yes, Chair, and
And it is be due 14 days, December 27th, 2024. And opposing party may provide any objections to the form of the order 7 days afterwards, which would be January 3rd, 2025. When the opposing party, when you receive that order, you'll have a chance to review it and file any written objections to it.
That's related to the accuracy of the order, right? Because the board did already make its
Yeah.
decision.
This,
Thank
it's
you.
not that's not a chance for us to reconsider our decision. Once we've reached our decision in a public meeting, then we don't change that. Okay, thank you very much. And we're going to move on now to the contested case hearing, which is Mr. Belisario's complaint. Hang on, I'll find it and announce it. Okay, I would like to call case number, the case of Joaquin Belisario, PL-BOA. Yeah, do we need a 5-minute recess?
You can ask if you want
Do
a
do we
short
have a
recess.
short recess? I think it would be good to have 5 minutes since we're switching. Let's do that. We'll now take a 5-minute recess. Thank you. All right, we'll call the meeting back to order and take up the matter of the petition of Joaquin Belisario. Let me find my numbers so I state it correctly. PLB-BOA-2024-000-101. This is wait a minute. Thank you. I've lost my. This is appeal of the decision by the Director of Public Works dated February 20th, 2024 regarding a finding of no violation, which is DPW 24-009. There are no public testifiers that have appeared, correct? Nobody here to testify as a member of the public simply? Okay. Then if you would introduce yourselves, parties, state your name for the record and appearances. We'll start with the appellant.
Mr. Belisario, can you please turn on your mic and speak into that?
Joaquin Belisario. Val, thank you.
And my understanding is you have standby counsel, is that correct?
Yes.
Can you please introduce your standby counsel?
Standby counsel Sarah Haig by Zoom.
Okay, and her presence is, you're still pro se, she's just here to assist you.
She's representing me under limited counsel, as limited counsel. But I am pro se.
Okay, so I understand Ms. Haig is on Zoom. Can you please describe for the board the limitation of your representation?
I'm sorry.
I'm addressing Ms. Haig.
Oh.
Yes, I'm just assisting Mr. Belisario today. He'll be speaking, but I'm here to listen and confer with him as necessary. So if we can have leave of the court to communicate via text so that he can ask me questions as he needs.
Yes, you could do that. Okay, Mr. Belisario, when you speak, you will have to keep that mic kind of close to your mouth. I know it's a little bit of a pain, but otherwise it doesn't really work very well. And most, okay, and no. Sorry. Oh, okay, yes, the landowner, please. Introduce yourself.
Chair Lewis and board, my name is Patrick Wong. I'm an attorney and I represent Jeffrey Dugan, a property owner in the subdivision. Also present in the chambers is Patrick McDonald, another property owner, another property owner in the subdivision. Patrick McDonald. He's in the audience back there.
He's also a landowner.
He's also a landowner in the same subdivision involving the same dispute.
But he's not the landowner of the subject property. Correct or not?
Well, the target of the action is Mr. Dugan, who is also here, Jeffrey Dugan.
Right. Okay.
Good morning again, Chair, fellow board members, Deputy Corporation Counsel Sinclair Solis Ferguson for the for the Department of Public Works, County of Hawaii. I didn't catch the rules require that one person for each party have the authority to do objections. Was that asked? Is it going to be Mr. Belisario or Mrs. Haig?
Mr. Belisario, will you be making objections to evidence or testimony? Do you know how to do that?
Yes, possibly.
Okay. When you make an objection, and this goes for both parties, when we make an objection, the witness should not answer until we rule on the objection.
So, just for clarity, on my sake, I believe Mrs. Sinclair indicated that only one person will be objecting. My attorney wouldn't be able to object.
Correct. You will be making the objections. You're pro se, you're doing the presentation.
Okay.
Yep.
Chair, one more thing. Under Rule 3-12, I'd like to make a motion to dismiss, an oral motion to dismiss before we proceed.
Okay. So you're doing that right now?
Can I?
Okay.
Okay.
All right.
So I'd like to make a motion to dismiss, and this is based on two legal principles. The first legal principle, okay, before I get there, this motion is made under Rule 3-12, which states that a motion can be made before, during, or after a hearing. So the first principle, legal principle, is the principle of res judicata. So in this matter, Mr. Belisario has filed 3 separate complaints, and that's in the record on appeal. So he, against the same roadway. So he filed a complaint, it was investigated and closed, and he didn't do an appeal, so it was closed. He filed another complaint against the project, complaint number 2, it was investigated, it was closed. He filed a third complaint, it was investigated and closed. And on that third complaint, he was provided notice on February 5th in writing that complaint number 3 was closed with the finding of no violation. He didn't submit this appeal until 37 days later. So on 2 separate grounds, res judicata being that the matter's already been decided 1, 2, and 3 times, and also on the separate grounds that this current appeal was not timely filed. It wasn't filed within the 30-day deadline. And on that basis, on both of those bases, I'd ask that this matter be dismissed for lack of jurisdiction.
Okay. I'm going to ask Mr. Wong his position on that.
We will
Motion.
join in that motion.
Okay.
I believe I responded to that during an email showing the official letter dated February 20th, which is also recognized on the Board of Appeals acknowledgement letter to me, that the document actually received was dated closure of 009, was dated February 20th. I have email exhibits that show it being delivered to me on February 23rd. And to that end, that's the official documentation that recognizes officially the closure of DPW 009. As to Mr. Sinclair's issue on res judicata, the complaint 408 mirrored, was closed. There was no appeal filed, but there was communications with the county's engineering department for a meeting discussing the closure of that DPW 408. At that meeting, I was advised that DPW 8 would remain closed and request and I was instructed to submit a new complaint, which basically mirrored the first complaint, but in much more detail, along with a significant amount of videotapes, exhibits. I think you've seen what I've submitted there. So as far as res judicata goes, the new complaint 009 actually contains more detailed violations of the code or deviations from the code, and moves into a different level of complaint. And again, this was at the instruction of a meeting that was held between Dion Gonzalez, Mr. Jun So, and Mr. Sanford Acquioni. So I would object to this because the res judicata issue is not applicable, because the new complaint is not only requested, but contains newer information that is not resolved in 408. And by the date on the letter itself indicates February 20th. And the email reflects receiving of that February 23rd, well inside the 30-day window.
Okay, reply, please.
Thank you, Chair. So he just admitted that complaint number 3. So let me take it a step back. So complaint number 2 was filed on May 9, 2023. And he received notice that that complaint was closed in a letter dated October 12, 2023. So that was quite some time ago, over a year ago. So he would have had 30 days, even assuming that wasn't that an appeal for that letter wasn't precluded by res judicata. He would have had 30 days from then, which would have been November 2023. What he just stated was that his January 4th, 2024 complaint, in his own words, mirrored complaint number 2. It just provided a little bit more detail. So the department's position is when they get a complaint, they go and they investigate it for violations. They'll, you know, if somebody complains about, let's just for an example, grading beyond the setback, and they go there and they see another violation, they don't ignore the other violation. They review the project for any and all violations. And if there are violation, they'll issue a notice of violation. So in this case, I think it's pretty clear that he's had 3 bites at the same apple. And each time the finding has come back the same thing. There's no violation. The landowner is complying with the notice of violation. The landowner got a permit. The licensed civil engineer submitted the grading plan, in which I know it wasn't required in this case because a licensed engineer is only required when there's a certain level of grading. I think it's a certain level which wasn't met in this case, so it wasn't required. So on those grounds, res judicata, and then there's an email sent to him February 5th, and it's clearly stating for the 3rd time that there's no violation on this project. It's closed. And so he had 30 days from that time, and he just didn't meet it. So on both of those grounds, we'd ask that this matter be dismissed. Thank you.
What is the difference? Can somebody tell me the difference between the complaint that we have before us now and the one just prior to it? Whoever can answer that. Mr. Wong?
Chair, I believe it's identical. If you take a look at both complaints, they cite his contentions that our client built a private driveway without the proper permits. This issue has been arbitrated twice. And if you look at our exhibits, what you have here today is what I characterize as an attempt to forum shop and to find a different result. He failed to appeal the arbitration awards that are attached as exhibits to.
Little louder.
He failed to appeal those arbitration awards, didn't like it. He's stuck with it, and he's here with you trying to relitigate those issues. If you look at all his exhibits, they all stem from the arbitrations that we've had. We prevailed in both. There's subsequent restraining orders my client filed. We prevailed on that. That's an exhibit. Mr. Belisario referenced his restraining order declarations, and he filed complaints with the Office of Disciplinary Counsel against my client and myself as a last-ditch effort to lash out. This is a last proceeding that he's taken everything that was previously arbitrated and ruled against him, and he's bringing it to you to find relief, even though untimely. So my recommendation would be to listen to Mr. Salas Ferguson, grant the motion, or we can move forward and have the hearing, and all you're going to hear is references to an arbitration award that was never appealed, that has been reduced to judgment. He's gone through multiple sets of attorneys, and we're talking about the same driveway. He has recourse within his CCNRs to do something about it. He could have appealed the arbitration awards, but he chose not to. And so we're another forum, same fact pattern, same road. And it really is my clients, the McDonald's and the Dugans, that removed an easement that ran through his parcel, created their private driveway on their flag lot so as not to have to deal with Mr. Belisario any further. They spent over $100,000.
All right, well, that's not relevant right now. But-
So I'm just telling you.
Okay, I understand. Mr. Belisario, the reason I didn't rule on your objection is it's argument, so we don't object to argument. You have a couple minutes, just
Yeah,
one.
I do, just in rebuttal,
Yes.
I brought this before this body before, in emails, but, again, the veracity of the arbitration award and the TRO are in question. And, that's for another matter. Personally, I accepted the driveway as awarded. Why we are here today is because you guys spoke about how important the codes are. I've been here in this town for 44 years, for over 4 decades, adhering to those codes, representing clients, using those codes in all their formations and modifications and generations over 4 decades. I've represented clients.
That's not relevant to this argument.
As far as the arbitration award, we're here today because of the not relitigating the arbitration. We're looking at how the driveway was built and the circumstances surrounding the building and permitting of the driveway and the inspection of the driveway as dictated by the code. And I prepared fully to go to trial, for lack of a better term, and make my arguments clear. Again, the DPW 408 and DPW 409, 009, I'm sorry, right? I did say they did mirror each other, so they kind of actually do, but there's a lot more detail in there because I was made to feel at that meeting that there was not enough detail in 408 to justify any finding of violations. And it was because of that comment that I requested that meeting, because there were obvious.
Okay, I'm going to stop you now in this argument because we've heard this now. If you have a new argument,
No, that's just the argument. We're here to just to figure out and determine whether or not the Hawaii County codes were followed to the letter, and if there was improper deviation from those codes that favored the landowner.
Okay.
Chair, can I just address your original question, but just very briefly?
Very brief.
So the complaints are all the same, right? He's saying that there's a grading violation under Chapter 10, and it's been remedied, and the road received final inspection on May 24, 2023. So a long time ago. So to summarize the county's position, we ask that this be dismissed for not being filed in a timely manner in violation of the Board of Appeals rules, and on the additional grounds that this matter has already been examined previously, and res judicata would prohibit a re-examination of the same matter. Thank you.
All right, thank you.
Chair, would it help the board if I direct them to where the 2 complaints that the parties are talking about is located within the record on appeal?
It would,
that assist the board?
And there's actually 3 complaints that he filed.
right.
Okay, so
That's, yeah, they're all alleging
This
violations
one
of
and the one
Chapter
right
10.
before is probably.
my understanding is that the majority of the arguments being made by the parties today is regarding Mr. Belisario's complaint that was made on May 9th, 2023, and January 4th, 2024. Is that correct?
And also the complaint filed on December 9, 2021.
Yes.
3 complaints, yeah.
Yes, but I understand the majority of your arguments. That's the first complaint. And you're saying res judicata because of complaint 2 and 3. Is that correct?
Correct.
Okay. Would it help the board to tell you where that is on the record?
I would hear from the board members whether that they would like that.
Yes.
Okay. So on the record on appeal that was filed by the department for this case, document number 5 is Mr. Belisario's complaint that was dated May 9th, 2023. And document number 7 is Mr. Belisario's complaint dated January 4th, 2024. I do have printed copies here at my desk if you want to view it in person.
And for the board's edification, document 6 is the finding of no violation for document number
That's-
5.
So that's the no violation.
And document 8 is the finding of no violation for document number 7. And they're both saying the same thing. It's been investigated, there's no violation.
I'm sorry. We're looking at the. What are we referring to? The records on appeal presented by county council? What are we?
Presented by the department. I don't have page numbers, I'm sorry, because each document has its own page number.
But are we looking at the submittal for from the county on records of appeal?
That is correct.
Okay, so.
So the record on appeal document numbers 5 and 6. 5 is the complaint. 6 is the department's response that there's no violation. Document 7 and 8. Document 7 is Belisario's 3rd complaint. Document 8 is the department's communication that again, there's no violation.
I'm sorry, counsel. We're looking at page numbers, document 1, page 5.
Sorry, Mr. Belisario, it's
Yes.
documents 5, 6, 7, and 8. And the-
Document 5.
Same issue.
Page 1.
And Chair, can I just add one last comment to the county's motion? Res judicata is a principle that, you know, it means, it basically prohibits something from being re-litigated. So it's really apt to this situation where somebody can keep filing, even if today, say for example, if the board did grant this motion to dismiss for not being timely filed, Mr. Belisario could go today down to DPW and say, there's a grading violation, investigate it, no finding a violation, and then he could appeal that again if we didn't have that principle of res judicata. That's what that prevents, is somebody filing the same allegations and then having to relitigate it over and over. So I just wanted to clarify that point about res judicata.
May I?
At this point, I'm allowing the board to take a look at these exhibits again. And then we would be ready then for a motion, and we can certainly have a discussion.
May I just add one thing? Mayor,
Well,
it'll be very short.
all right.
DPW 408 and DPW 009. If you look at their, if you look at the text in the description of the complaint, it's clear to see that.
That's what we've been doing, Mr. Belisario. We've been
All
doing
right, I
it.
just want to make that point.
Yeah. No, you've made it, and we do understand it. So
They want recess in place. You want to ask them if they want to recess in place to look at the.
okay, yeah. Did the board members need recess, or are you ready for motion and then discussion? Okay.
All right. It appears that at least one member is ready.
Okay. You can make your motion one way or another. It doesn't matter. We'll have a discussion and a vote. The motion being whether, to grant or deny the department's motion to dismiss based on one or both concepts.
I'd like to make a motion to grant the department's motion to deny,
To dismiss.
to dismiss.
Is there a particular ground that you're granting on?
I don't, based on the fact that the filings were too late and past the deadline.
And do you want to address the matter of res judicata?
No.
I'll second it. Okay, we have a motion and a discussion to grant the motion based on timeliness of the filing. Discussion on that? Does anybody have any questions of anybody regarding this? I can't tell if she's working. Yeah. Okay. Noe, do you have a question or? No.
I have a question for Mr. Belisario. Mr. Belisario. Hello, I'm Noy Psyche, Vice Chair of the board. I was wondering, after you did the arbitration, why did you not appeal it? I mean, you seem to have still something that you wanted to address, which led to the third complaint. And I'm just wondering, what was your thinking?
Yes, my thinking has always been from, this has been a 13-year ordeal with my neighbors. And it culminated into the past 3.5 years with the landowner taking over as an attorney, our legal matters. In my case, whether I was represented correctly or whether the conduct of everyone, the attorneys involved, they are before the Office of Disciplinary Counsel, which found grounds to initiate investigations, which are still ongoing. And so
Yeah, I'm going to stop you, Mr. Belisario. You're not addressing the question that you've been asked.
yeah, so I'm getting there. As far as the arbitration award to build the driveway, I was fine with that. You know what I mean? You depend upon oversight committees and the judiciary to honor and to be correct in their judgment. It's not always perfect, but that's all we have. I fully accepted the arbitration award, as much as it disappointed me. And I did not at any point, challenge that. And I did not appeal it, as counsel has noted. But as a 44-year draftsman and planning consultant, I personally know what the codes are and how this thing should be built. I've done hundreds of these over the years. And construction started, and one day Mr. Soul showed up and asked me.
Okay, I'm gonna stop you because you're not addressing her question, which
Sure,
is
that's-
why you did not, just why
I
did you
get-
not?
I get the
appeal?
gist of what you're saying, Mr. Belisario. Thank you.
I accepted the arbitration. It was not until the complaint was, an anonymous complaint was filed, and I was identified as the complainant when I was not, that triggered these complaints.
Okay, thank you.
Okay, thank you, thank you.
So I'm just going to remind the board, at this point, there is a motion on the floor. So it is otherwise inappropriate to be asking questions of the parties, because right now, that portion of this hearing regarding the motion is closed. And it is just open for discussion between the members based on the motion that's on the floor, which is to affirm or rather grant the motion to dismiss based on timeliness.
Any further discussion? I would like to amend the motion,
You can
propose an amendment.
suggest that the mover make an amendment, because ultimately the amendment's got to come from the mover.
Okay. I would suggest that we amend this motion to also grant the motion to dismiss on the grounds, maybe not so much res judicata, which I'm not thoroughly convinced applies at this level. However, issue preclusion, whatever you want to call it, relitigating an issue that has been already decided, obviously can't continue to happen, or people would be filing and refiling with a few additional little facts, whereas the issue is the same. The issue here, I think we can all recognize what the issue is, has been on all these complaints. And the department has looked at it, has made its findings, and so whether we call it res judicata or issue preclusion, I would like to also add that as a grounds for dismissal.
You need to move for that.
I'd like to make a motion that we adopt the changes as recommended by the chair.
Okay.
I'll
I
second.
second.
Okay.
So I think Noy,
We need a discussion on the new motion.
so this is a motion to amend. So now it's been moved and seconded, so it's open for discussion for this amendment.
Whether to include that additional grounds. Okay, hearing no discussion, we'll take a vote. All in favor? At this point? Aye.
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 Aye. All opposed? Nay.
Hearing none.
Hearing none, then we now will vote on the motion itself, correct?
So
Whether to
Hearing-
grant or deny.
So hearing none, the motion to amend is adopted. The main motion has thus been amended. That is now open for discussion for the board.
So yes, whether to grant or deny this motion now is open for discussion.
Mhm.
And hearing none, then we'll take the roll call vote on the motion.
Okay, very good.
Excuse me. I have been advised by my attorney, to make one comment, and I'd like to make that comment before the vote.
How long do you plan on?
It's very short.
Okay,
2 seconds maybe. My attorney is informing me that, that res judicata applies to view action and that, res judicata, this is not barred by res judicata because this is an appeal of a decision. The res judicata does not apply. That's my.
all right, thank you. Okay, we're ready for the roll call vote.
Okay, Member Martin,
Yes.
Member McNamara,
Yes.
Member Psyche,
Yes,
and Chair Lewis.
Yes.
You have 4 ayes, the motion passes.
Okay, that concludes this matter.
The
And
order,
So you're going to need a form of the order.
right, so Mr. Silas Ferguson, if you will prepare an order for our consideration, that will be available, or that will be due on January. Hang on, I gotta get those dates for you and for Mr. Belisario especially. Thank you so much. So that would be due in 14 days, which is December 27th, 2024. And then, Mr. Belisario, you may provide in writing any objections to the form of the order that is prepared within 7 days thereafter, which would be January 3rd, 2025. Thank you. All right, that matter is concluded then. I thank everybody for their time and their input and consideration here today. So we're moving on to our last,
Thank you. Have a good day.
yeah,
Thank you.
yes,
Minutes.
yeah. Right, yeah. Okay, we're moving on to the adoption of the minutes from our prior meeting. Everybody had a chance to take a look at those minutes from the October 11th meeting.
Yes.
Okay, I'd entertain a motion to approve the minutes.
Make a motion to approve the October 11th Board of Appeals minutes.
I second.
Discussion. Discussion for me is that there's just one minor typo on page 2. It's the long paragraph at the top. And it is towards the end, it says, was not clearly erroneous, was not an abuse of discretion, it's an abuse of discretion. If you can find the word abusive, so that just needs to be turned into abuse of.
Make a motion to make the change as noted by the chair.
Did you find it, April? Okay. Okay, good.
I'll second it.
Okay, any discussion, any further discussion? All right, all in favor to adopt the minutes, say aye.
Aye.
And
Aye.
any opposed? Hearing no opposition, the minutes are approved.
So the amendment to the minutes are approved. So now you have the motion to amend the minutes has been approved. So
I thought-
one more vote to
Oh,
approve the
okay.
minutes as amended.
Okay, I'm so sorry. I skipped a step there. So now, do I need a motion or we have a motion?
You have
Seconded it.
We have a motion to adopt the minutes as amended.
Second.
I'll second that.
And it's seconded and discussion is not,
It's like Jeopardy.
no discussion. And now all in favor?
Aye.
Aye or yes, and all opposed?
I'll just
And-
note for the record that Ms. Psyche did in fact say aye, even though her
Yes,
mic
her
did not
lips
catch.
moved and they look like they Shake your head, yes.
Yes.
All right. Minutes are approved. Thank you. And we have any announcements or administrative matters?
Sylvia, Deputy Corporation Counsel Sylvia Wan, as far as updates on appeals filed on Board of Appeals decisions, I will note that there was 3 notable decisions that have reached their final judgment. First one being Lawrence Ford, John Kuntz, Don Davis, Philip Kozarek, William Robert Gage, and Rebecca Gage. That particular matter, which was 3CV 22 200, final judgment was entered on December 2nd, 2024. In that matter, it was reversing the Board of Appeals decision, allowing a short-term vacation rental on an agricultural property. I'll note that part of the reason for that judgment is a Supreme Court case, Linda Rosehill and a number of other parties versus the State of Hawaii Land Use Commission and County of Hawaii, Supreme Court decision, which was filed. I'm sorry, I'm forgetting my dates. On September 24th, 2024, made a holding finding that short-term vacation rentals are not allowed on agricultural land. That's just the shorthand version. There is more depth into that. So basically, the more recent judgment filed on December 2nd, 2024 is consistent with the Rosehill finding. So just so the board is aware, Mr. Ford and Mr. Gage's cases are likely to come back onto the agenda to correct that order. And then secondly, for the Rosehill cases, I think there's a total of, I'm sorry, April, how many was there? About 16? Those cases will likely have to come back onto the board's agenda as well for corrections. The last matter is Ms. Rohr versus Board of Appeals. Planning Department, this case is a 3CCV-23-100. That particular matter, I had reported on last meeting that the judge had entered a findings of fact conclusion of law affirming the board's decision. The final judgment was entered on November 15th, 2024. I will just note that Ms. Rohr does have a different case before the board, a collateral matter that has been stayed pending the outcome of this particular case. My understanding is that she still has the ability to appeal. So that case that has been stayed pending appeal may or may not come back on the board's agenda.
To appeal to the Supreme Court.
She could still appeal to a higher court because this final judgment is from our circuit court. So theoretically, she still has the ability to appeal to either the Intermediate Court of Appeals and likewise. So I just want to make you aware. But, you know, that decision hasn't been, she still has time. That is my updates. I will provide these judgments to the board members just for your edification. And more, it's just an awareness that, you know, some of these cases might be coming back.
And there could be new ones with similar issues, right? That are already coming up to fight.
I don't think we have any current petitions relating to the same issue. But back at this point in time, when it was a point of contention, there were several cases, several meaning, I think in excess of 20. Okay, thank you. That concludes my update.
Aloha, Chair. I just want to note that there is a member of the public in the waiting room that had signed up for testimony for the Maragos case. So I just want to be transparent. We haven't let them in because we just saw them join. And that case has been concluded. So we just wanted to make that clear on the record. We have messaged them in the waiting room, but we could put them on and state that in the meeting if you so choose.
This is a person in the waiting room on Zoom?
Correct.
No, I just feel like it might be the best 3 minutes we ever.
Well, just
Yeah, well, let's allow them to testify. I'll let them know before we do that we've made our decision and if they still want to go on the record.
Aloha Chair, we have Jane DeMello online who I think had signed up for testimony.
Okay, I just wanted to mention to you that we have already heard this matter and made our decision. Although if you would like to state, make your 3-minute testimony for the record, I'm allowing that.
I'll just let you know that
Your mic is muted, I mean, sorry.
Oh, okay. Hi, I'm Jane. I just don't understand if you have a meeting, but you've already made your decision. What's the purpose of us joining in on the meeting again?
Just if you want to state your position for the record, I don't exactly know when you requested or when you appeared. So I'm just offering you that.
Okay, I just thought that this was an opportunity before you make your decision for us to voice our concerns. Anyway,
Right, that happened already, but
okay. Well, I live on Kamakani Street. I am right on that corner where you take the turn to where the barrier or the guardrail is supposed to be removed. And I just wanted to note that if the county is obligated to give us notification that something like this is happening in our neighborhood, because if so, I did not receive anything. And I am one of the original owners in Cook's Landing, where there were only 8 homes at the time. And so when we purchased our home, our understanding was that the barrier was not going to be open, and that the road that goes all the way down to Kamakani eventually, what is that? The end of the dead end road was eventually going to be open, but something happened where it was retracted and that never happened or never occurred. So here we are, and I understand that there's developments. We're in a residence here on the mainland right now, so I don't even see the front of my home. I hear about what's happening there because my son is there. So, and our neighbors are there. So my concern as a homeowner of 30 years is that this is all occurring and we have nothing to say about it. Because it appears that people are making decisions, and I just hope it swings our way today. I don't know what your decision is today, but I've lived there all my life. I've raised my children. They are now 33 and 31. Kids play on that street. And it's unfortunate that other people who do not live in our neighborhood are making these decisions. So just wanted to say my piece. Thank you.
Thank you. You're welcome to listen to the full hearing on YouTube. I hope you know that's available to you if you'd like to hear the deliberations today. Thank you very much.
Hi, can I speak?
My
I'm
husband,
I'm
Shane.
James' husband, and I guess my testimony didn't reach you guys.
State
Like,
your name
my,
and
my name is Shane DiMello, and I'm James' husband. And basically what I gave to one of my neighbors to forward to you guys was what I was told before we purchased that house. And we were told that that barrier was not going to be taken down until the through road on Kamakani was completed, because that road is not a normal traffic road. And just to give you guys some insight, before that railing they attempted to take down at one time. And when I approached the people that were taking it down, I assumed they were county workers. They said that no, yeah, it's going to be taken down. We just doing our job. And I told them what I was told when I bought the property. And next thing I know, the railing went back up. But even though the railing was up, we still endured a lot of traffic of people going around the railing. If you go there and actually see it, you'll see that they may have taken them down now, that community members put up rocks to stop people from going around the barrier. And what ended up happening was that absolutely stopped the traffic. And this is with the barrier up now, that we had traffic. And it was I incurred many times when I had to voice to people coming around the turn, because most of them were locals, because they become very comfortable coming down the hill and making a turn. Sometimes they speeding. I've incurred people go popping the curb into my lawn. I live on the corner, on that very corner from what is that, Paikayapahu and Kaminani on the Makai side. So making the turn is very sharp. When you're going too fast, a lot of times you drift into the other lane.
We've
the
had
oncoming
people
lane.
fly into our yard.
Yeah, we've had people.
Okay,
coming,
so
yeah.
just a FYI.
And at the time, we had law enforcement chasing people down, people
Yeah.
using that hill, and what they would do was go around the curb, but the law enforcement wouldn't ride that curb because that's not their car, I guess, or they don't want to pursue it. But just so you guys are aware, you guys should come and take a look and see exactly what we're talking about, because it was really pretty bad.
Oh, sorry. Hold on a second.
Yeah, so to take down that guardrail and treating it like a normal traffic roadway would be pretty.
It's concerning.
It's very concerning, especially for our house. We're on that turn is very sharp. When you guys see it, it's not a normal turn. And might I ask, have any of you guys gone to see the area or to visually take a look at the
area
of the roadway?
Mr. Danilo, thank you for your comments. Again, I'll just encourage you to look at the deliberations and decision on YouTube if you care to see what happened. And we thank you for your input.
Okay, so on YouTube, where do we go on YouTube for the
The
hearing?
County of Hawaii.
County of Hawaii?
Yeah, they have a channel.
Okay.
Oh, I'm sorry, Planning Department. Sorry. Yeah, the County of Hawaii Planning Department has its own YouTube channel, and all their committees are on there. Thank you so much.
Okay,
thank you. Aloha.
Okay, aloha. Now we will call this meeting concluded. And-
Announcements?
Oh, any announcements? Any further announcements?
Happy holidays.
Happy holidays.
Okay.
And the meeting is adjourned. Thank you so much.
Oh, so that's it. That's it?
Bye, guys.
We'll see you soon. Happy holidays.
Happy holidays.